Hi everyone, I'm Terry Mottershead, the Executive Director of the Centre for Legal Innovation at the College of Law, and I'm absolutely delighted to welcome you back to this eDiscovery mini-series that we are offering to you in collaboration with Enhanced Litigation Management Solutions. And we have Kate Clark back from the other episodes, for these episodes, and more episodes still to come. We're about halfway through at this particular point in time. Kate, as you will know, for those of you that have been with us on other episodes, is the CEO of ELMS. So that's a shorthand acronym for it that we're using as well. And of course, we also get to welcome back Kira Cook this time as well for this episode. So as you can see on the screen in front of you, this one is all about doing fabulous legal reviews, and particularly the team that you need to kind of get that done in the most effective and efficient way that you possibly can. It's been a fantastic series so far, really enjoying it, learning so much. Kate, delighted to hand over to you and learn some more today. So over to you, Kate.
Thank you so much, Terry, for that wonderful introduction again. And for anybody who has missed the first couple of episodes, they can be found on the Centre of Legal Innovation's website. So please feel free to jump in and check them out if you haven't had a chance to look at them so far. If you would like a more customised session for your team, please just reach out to us. We often go out to law firms and do educational sessions, and we would be more than happy to do that for your firm if you need something specific. So as we have showed you in the last episode, this is the eDiscovery timeline that we follow that pretty much lines up with your litigation process. And our processes start from the end of pleadings and continue right through to the e-trial. And for every step of the process, you can add a bit of tech in to help you work more efficiently along the way. Now, of course, in addition to the processes we follow, we use specialist litigation databases to manage the disclosure process and to prepare for trial. In the last session, I covered off on the identification and collection of documents. Sam covered preparing the document management protocol and what is covered by that protocol. He also talked about setting up the litigation database and processing your documents into the database. And then Kira covered off on preparing documents prior to legal review. So now in this episode, we're going to get into the legal review process. Yippee, I can hear you all saying. And you're going to need to understand who you need on your team so that you can conduct an efficient legal review and get them across legal issues really quickly. We're going to talk to you about what are the options for legal review, disclosure, and then finally, we're going to briefly cover e-trials. And again, today we are going to assume that your documents are in a litigation database and you will be doing your review electronically. So let's get into it now and understand firstly, what is legal review? So legal review is simply the review of your client's documents to determine relevance to your case prior to disclosure to the other side. But for ELMS, it's all about building your client's story from the start of the project to the end of the project, and understanding what documents are good or bad for your case. Now, oftentimes lawyers don't actually like the legal review process because it can be pretty time consuming and a bit tedious, but of course it is an absolute necessary evil. So we can help you get through this process efficiently and with as little pain as possible. So what we want you to do is just to sit back, grab yourself a cup of tea and relax because we've got you covered. Now we're going to talk about what are the options for developing your legal review team. So firstly, which is the most common option, is to have your in-house legal team conduct the legal review. And this is where the law firm does the legal review and either uses their existing staff, or if the matter's really large or too large for your existing team, you could employ some contract paralegals or lawyers for the length of the review. Now, there are lots of companies out there who can provide legal review teams, but at ELMS, we would recommend Yeagle if you're looking for paralegal staff, and a company called Free Range Lawyers if you are wanting a more experienced remote legal review team. Free Range Lawyers can offer experienced senior legal reviewers, which might be a good option if your timeframes are really short and you have really complex legal issues. The second option is to utilise your in-house team and your contracted reviewers and have ELMS or an eDiscovery provider project manage that process for you. So the benefit of this option is to reduce the time for your senior legal team members in managing the review team. And it can be a good option depending on the level of experience of your eDiscovery provider. We're going to talk more about that option shortly. And the final option is to outsource the legal review process entirely to a provider like someone like Integron. So this process is called managed legal review. There's a couple of things that you need to think about when instructing a managed legal review team. So firstly, you want to try and appoint one lawyer to instruct and answer all of the questions, because this will reduce your likelihood of inconsistency. That lawyer needs to be involved in more than just the initial briefing. They also need to work with the review team on calibration exercises, responding to any queries and providing feedback to the team as the review progresses. And that lawyer needs to stay involved on an ongoing basis as long as the external legal review team needs it. This approach is going to help you to avoid costly mistakes and re-review of documents. It is, of course, critical to always provide clear and easy to understand instructions to the review team and to respond really quickly to their questions and provide them with regular feedback. And finally, you want to let the legal review team know that they should feel really confident to shove their hand up in the air and tell us if there's any anomalies in the review population. So an example of an anomaly might be, you know, a particular search term is producing a really massive amount of irrelevant material, or a CAL model just isn't working as you would expect it, or you are seeing a whole lot of duplicates. So you want to jump on these type of anomalies straight away so that you can avoid wasted review time and cost. Now let's talk about when ELMs get asked to project manage a legal review team for larger matters. So our approach to briefing a review team is really designed to get them quickly across the issues so that they have more knowledge of the case than they would if they were simply reviewing a pleading. So really what you're trying to achieve is that when you start the review, that they are sufficiently across all of the issues so that they can understand the relevance decisions, and those relevance decisions are correct from the start, not a couple of weeks into the review and then you have to re-review the documents that have already been reviewed. And if you have a smaller matter, I suppose the same applies. It could just be done on a smaller scale. So firstly, at ELMS, we would prepare a briefing paper that they can use as a handbook throughout the matter. And that briefing paper for us would include a general explanation of the proceedings, including a chronology of the steps in the proceedings so far, so that the team knows exactly what stage you're at. We would give them a high-level timeline of events, an explanation of all of the parties and what their role was and how they relate to each other, an explanation of the legal teams involved, including any insurers, litigation funders, and dirty experts, if there are any. We would give them a structured diagram to explain the parties and the legal teams visually in case they prefer to learn in that way. We want to give them an explanation of the project or the subject matter of the claim, and of course, an explanation of the claims and the defences to those claims. They'll need a list of key issues for determination and a list of key witnesses, including their role and their start and end dates on the projects. And we also need to give them the broad categories of documents that would likely to be relevant and a brief explanation of disclosure, just as a bit of a recap for them. We'll give them a list of all the practice directions that apply to the matter and an explanation of what is a confidential document. You also need to give them an explanation of a privilege document. So what you want to cover here is what is legal professional privilege, without prejudice privilege, common interest privilege, and in-house counsel privilege. We all know that determining privilege, certainly in-house counsel privilege, can be really tricky at times. So it's nice to have a refresher and open that conversation with them so that they feel comfortable to come and ask you questions all the time. We then want to give them a list of all the potentially privileged names and organisations that they might come across. So this would include all of the in-house counsel and any admin people that may have sent emails on their behalf, all the names of all the lawyers, whether they are past or present, that have worked on the matter, the insurers and all of their names, any dirty witnesses or litigation funders if there are any. We also want to give them an explanation of the approach to coding of documents for relevance, which we will cover off in the next few slides, and a list of the commonly used phrases, terms, and acronyms. At ELMS, we do a lot of construction work, and construction projects often have a lot of acronyms. So if you can give them a list up front, it saves them time working out what those acronyms mean by themselves down the track. And finally, we want to give them a list of the key documents that we would like them to read before they start reviewing. So we would recommend that paralegals or junior team members read into a matter in a particular order, as it's going to help them get across the issues quickly and be more effective in the initial stages of the review. So firstly, you might start with mediation position papers if there are any legal summary of the claims that have been prepared for your client, barrister's advices, draft witness statements or summaries, and key correspondence. And the reason why you want those types of documents is because they usually summarise your claims and the defences to those claims very succinctly, and they're easy to read. And then finally, you want to give them the pleadings. Now, some law firms also prepare a pleadings matrix or a pleadings table that sets out the pleadings in a bit of a different format. So I would suggest if you're preparing one of those documents, you give them that to read and then they read the pleadings. So it's really important to get them to read in a way that they can get a sense for the whole story as they go, as opposed to just reading the pleadings up front, which sometimes can be fairly formulaic and hard to get your head across. So now that we know that who's going to be in our legal review team and they've been briefed appropriately, I am sure at this stage they are really full of excitement and energy and ready to get going with the review. So the next thing we need to think about is our first steps as eDiscovery providers. So this is a really high level process that we follow at ELMS to conduct an efficient legal review process. Firstly, we need to understand what the requirements of the review are and what deadlines have already been set by the court. Then we need to discuss the different methods for legal review with you and help you to identify which method is best to suit your requirements and your time frame. And then next, we're going to train the legal team on the method you've chosen, and we're going to monitor and quality check the relevance coding for inconsistencies and report to you regularly on the progress of the review. So now let's talk about understanding the scope of the review. And this involves understanding the timeline and any deadlines that have been set, understanding, of course, how many documents are involved and what is the size of the team of the reviewers that are available to assist. And then we also want to understand the complexity of your matter or the legal issues. So we need to understand this so that we can work out who is reviewing what. If you've got multiple and really complex legal issues, perhaps not everyone will be across all of those issues. So you might want to direct certain types of documents or groups of documents to particular individuals for review. So we just need to understand that at the start so we can direct those individuals in a particular way. And then we need to understand the legal coding requirements. So legal coding is where a lawyer reviews a document and decides whether or not it is relevant to the case and codes that document in the litigation database. Litigation databases streamline this process significantly by providing legal coding panels for the lawyers to complete as they're reviewing. You simply just review the document and then you select its relevance by ticking a button on the screen. The legal coding requirements are driven by a couple of factors. Firstly, the document management protocol that's been agreed by the parties, and then what other information you would like to capture during the review process so that you only need to do one pass over the documents. So some examples of standard legal coding requirements are firstly, whether the document is relevant or not relevant. You want to know whether the document is privileged and on what basis it is privileged. And you want to know whether it is confidential and what basis it is confidential. So we also need to know whether you will be coding to importance and favourability of documents. So for example, if your document is favourable or not favourable to your case and on what scale. We need to know whether you will be coding handwritten notes and the author of those handwritten notes, which might make these documents easier to find later on in the process if your searching is not picking up handwritten documents. Then we need to know whether you're going to be coding to case issues as you go so that you can build issue bundles and chronologies and search for documents related to a particular issue while you're using the database. We're then going to talk to you about whether or not it's important for the reviewer to see the file path of the documents in their original location on your client's network. Now, this could indicate to them whether the document was created for the dominant purpose of litigation and assist them to determine whether the document should be marked as privileged or not. And once we have all of that information, we're going to customize a coding panel for your legal team, and it is going to be in a logical order, and it is going to reduce the number of clicks and scrolling that's required so that we can speed up your legal review process. Next, we need to understand how you would like to structure your review. So for example, do you want to do a first pass junk culling review, and then a second pass relevance or issue coding, and then finally a QA process to check for consistency of coding? We're going to need to know whether you would like to do one tranche or multiple tranches of disclosure so we can start to get that organised, and what options you would like to do to conduct your review. So I'm now going to hand over to Kira, who's going to talk you through all of the different options for legal review so that you can understand how the litigation database can best help you. Over to you, Kira.
Thanks, Kate. So I'm going to briefly talk you through the different options for legal review, from linear review right through to technology assisted review. Depending on the type of matter and deadline, the method for legal review you will choose will be designed to meet those requirements. You can use multiple options at one time to get the best benefit from the technology. So now let's go through the different options for legal review. First up, we have linear or chronological review. Linear review is the process whereby the legal team reviews each document in chronological order from start to the end. For small matters, so anything under 5,000 to 10,000 documents, this may be an appropriate way to review. When your matter's a little bit larger, you may start to find some issues with linear review, particularly where there is more than one person doing the review chronologically. For example, if an email is reviewed by one person, and then the reply to that email is reviewed by a second person, it can be very difficult for any of the reviewers to piece together the storyline of those emails to get the full picture. Having the full story may actually impact the decision of whether some or all of those emails are relevant or not. So there are some improvements that can be made on the linear review process to assist you with reading the documents in context and getting across the facts faster and speeding up the process. One of those improvements is email threading, which is one way to speed up your review and read emails in context. So let's jump straight into it. Email threading groups together emails into a conversation thread. So when the legal team are reviewing the documents, they can view the whole conversation at once and tag them all as relevant or not. You're also then able to see the people or attachments being added or removed from the conversation or the email thread. So if you were reading those emails chronologically, you would see one today, a second reviewer would see the reply the next day, the third reviewer might see the reply to that reply in a week's time, and so on. So you can see how email threading can save hours in review time, and it allows the legal team to review all of the emails in context so that they can read the whole conversation from start to end and get across the content quickly. So in addition to email threading, the next two processes are great for reviewing documents in context. The first process is key document bundling, which groups together documents in the database so that they can be reviewed in context. This enables the legal team to understand the entire story from start to end in one go. For example, if you were to review all of the board minutes at once in chronological order from start to the end, you will understand the story and get across the facts or issues faster, rather than doing a chronological review. So if you were to review those documents in the chronological review, they could be reviewed by multiple lawyers or paralegals and not together. So it therefore takes longer for the legal team to get across the facts in the matter, and it is easy for key documents or key facts to be missed or not identified early on. Key document bundling can also assist you to identify large groups of documents that are not relevant to your case that could be bulk coded as not relevant or removed from the database completely. So removing these documents from your review helps your team to focus on the more important documents first. The second process is keyword searching, which is probably still the most used option in Australia. So grouping documents by keyword search is an effective means to locate relevant or irrelevant documents. But at ELMS, we would also suggest that you turn on continuous active learning, also known as CAL, which we'll cover shortly, so that the litigation database can help to categorize documents based on the tagging of the documents in the keyword searches that you run. As I said, keyword searches can be run to locate relevant documents, but it can also be used to remove irrelevant documents. As the legal team reviews the documents, they should be able to identify groups of documents which are not relevant and remove them from legal review in bulk. For example, they might identify documents that relate to another project or other jobs that their clients are working on at the same time. They may identify further junk documents that were not identified through the junk culling process. They may identify documents that relate to the project that is an issue but are not relevant and can be excluded. This can be a very effective process to reduce the amount of document volume quite quickly. When you do find these sets of documents, talk to us about running from further searches to find those documents and remove them from your legal review. The next two options we're going to discuss to speed up legal review are concept analysis and similar document analysis. Concept analysis enables you to identify documents with similar concepts. For example, if you were looking at a set of documents and you saw the words bank and money, you would know that this relates to a financial concept. If you were reviewing and saw the words bank and river, you would know that they are talking about an environmental concept. So concept analysis enables you to analyze and group documents by concept. You can also then view the analysis in a visual way, helping you to quickly understand what is in your document set. This can reduce legal review time as you are able to view the relevant documents with similar concepts so that you're looking at documents that are likely to be relevant first. Similar document analysis enables you to see similar or exact duplicate documents in one go and make a decision on their relevance and tagging at once. So let's explain what a similar document would look like in a litigation database. If you have a final report, similar documents might be drafts of that report. These are documents that contain mostly the same text and with some edits, and the software shows you those differences in the document so that you don't have to manually compare the documents word for word. Exact duplicates may also exist in the database. Now, I can hear you asking, why would there be exact duplicates in the database if the software's done its job? As mentioned by Sam in the previous episode, exact duplicates can exist in a litigation database. For example, you might have one attachment that's been attached to multiple emails. Therefore, exact duplicates will exist in the database, and you can bulk code them as opposed to having to review all of them and code them individually. Using this strategy means that you would code the attachment just once, and the coding of that document would be applied to all other individual exact duplicates of that document. This strategy is good for a few reasons. Firstly, rather than reviewing the same attachment multiple times, it just gets reviewed once, which in turn speeds up your review. Secondly, if you're using this technique in combination with continuous active learning, it assists the computer to learn quickly from your coding decisions, and your recall rate will increase as a result. And lastly, this strategy can also pick up any inconsistent coding within the team. So now for the showstopper, which is technology assistive review, or also known as TAR, predictive coding, continuous active learning, also known as CAL, or simple active learning, also known as SAL. So it's referred to in a couple of different ways. These can all assist with categorizing documents into an order with the most relevant documents first and the least relevant documents last. Essentially, the computer scores the documents between -1 and 1, and documents with a score closer to 1 are more likely to be relevant, and a document closer to -1 are more likely to be not relevant. So how does the scoring assist you during your legal review? Well, let me explain it in a way that makes a bit more sense. Everyone here has Google, right? You will notice that when you start searching for something in Google, it predicts based on the text that you type and the websites that you visit, what you are looking for and the things you want to find or buy. Next time you go into Google, you will notice the ads on the different pages for exactly what you wanted to buy based on your previous searches. The algorithm is learning from your previous behaviors, and it's giving you the most relevant products or services first. This is essentially what predictive coding is doing. So CAL, or predictive coding, whatever system you're using, it works like this. So the legal team reviews a sample of randomly selected documents in the database. They then decide on those documents as to whether they're relevant or not to the matter. The computer then takes those decisions and applies them to the rest of the documents. So what you're left with is a set of documents categorized into an order with the most relevant documents first and the least relevant documents last, based on the legal team's review. The computer then continues to learn and rescore the documents based on the continuous coding from the review team. The reason why CAL is so effective is that the legal team will review the most relevant documents first, and the documents will become decreasingly relevant. The legal team will be able to set parameters for the percentage of documents that are becoming irrelevant, and then decide whether they will review the rest of the documents or not. If not, ELMS will do some quality checking to ensure we've captured everything relevant, or the legal team will review the remaining documents in due course, generally last, so that they satisfy themselves that they are not relevant, but don't waste their time reviewing the least relevant documents up front first. At ELMS, we use continuous active learning, or CAL, on most of our matters, and we also use it as a quality checking process. The term we use for this quality checking process is review conflicts. So for example, if the software categorizes the document as relevant, but it's been coded as not relevant, there may be an error in the coding which you might want to have a look at. If a document has been coded as relevant, but it's low ranking, it also may indicate that there's some incorrect coding, so you'd also want to have a look at those as well. It's a really good idea to double check on individual coders and the documents. So now I'm going to hand back over to Kate, who's going to take you through review speed.
Thank you so much for that, Kira. Lots and lots of options to conduct a legal review these days. So now that you have an understanding of those options, we probably need to let you know how we calculate a time frame for how many documents the lawyers can review in 1 hour. When we're estimating timeframes for review for our clients, we generally estimate anywhere between 45 to 60 documents per hour, depending on the type of documents that are in your litigation database. Now, of course, if you have a set of one-page documents, that would mean you need to review 1 page every minute of every hour. And obviously, if you get hit with a 100-page report, then these numbers are going to blow out. And on the other side, if you can determine that a document is not relevant quickly, then you might do more than 60 documents an hour. But it's a good place to start with these types of numbers. Now, there are ways we can help you to speed up your legal review, and this is going to be dependent upon what is in your data set. But some tips include, firstly, having a really well-designed coding panel to reduce the number of clicks and scrolling. This is going to be really beneficial in your review and speed you up substantially. We're going to show you how to use some coding macros that can automatically select multiple coding decisions and move you straight to the next document, which reduces the number of clicks you need to make. Reviewing certain document types together so that you get used to the style of those document types and you know where to look for the critical information, that can be really useful to speed up your legal review. Then, of course, we have bulk tagging of exact duplicate documents, which Kira took you through a few minutes ago. This is going to reduce the time for review for all of the different versions of that document. And then having different legal team members review particular sets of documents that they have a specialist expertise in, as this is going to make the reviewing of those particular types of documents faster. And of course, using continuous active learning and a combination of the legal review options can certainly speed up your review process quite substantially. And as your eDiscovery provider, we're going to have lots of ideas of how to speed up the review. I would just recommend that you reach out and ask your provider, is there any way I can, reduce the number of clicks or speed up the legal review by reviewing documents in a different way? I'm sure they will have thousands and thousands of ideas to get you through the review of your documents really quickly. And then once you've decided on the method for legal review and the review has started, you of course need to monitor the progress of that review. So most of the litigation databases have a method of doing this, which looks something similar to what you can see on the screen now. And this enables you to see the progress of the review by individual and relevance category, and to therefore make decisions on the next steps. But please keep in mind that these stats need to be understood in conjunction with the method for legal review and the number of pages in each document. Sometimes it looks like an individual is just not achieving a lot in the review, but it might be just because they've hit lots and lots of large reports along the way. As you can see in these particular numbers, I'm an absolute gun at review, doing over 1,000 documents, whereas poor old Sam's only done 8 documents. I'm sure they were very long, very long reports, but you never know, I just might be a gun. So now Kira's going to run you through the quality checking coding decisions we make along the way, and have a good chat to you about how we quality check documents.
Thanks, Kate. So during the review process, it's really important to quality check the relevance coding as you go and correct any potential rogue relevance coding or incorrect decisions. At ELMS, we would actually meet with the lawyer in charge of the review regularly to identify any issues and get them resolved quickly. Quality checking and relevance coding may reveal that the reviewers might need a bit more guidance on what kind of documents are relevant or not relevant, It can also stimulate discussion within your team on the different documents they are coming across. And lastly, it ensures that the technology assisted review or CAL or whatever software that you're using is given its best chance at scoring the documents accurately. So continuous active learning and the other analytical features are very effective for quality checking relevance and coding decisions. Some examples of the quality checks you can easily run using the analytical functions are where a lawyer has tagged a document as relevant, but the software thinks it's not relevant, and vice versa. Where one lawyer has tagged a document as relevant, but another has tagged an exact duplicate of that document as not relevant. Where a lawyer has tagged a document that contains privileged or confidential terms as relevant, and therefore it has potential of being disclosed. And where a lawyer has tagged a document with similar concepts with different relevance decisions. So this can assist you to understand if one of the legal team members needs a bit more training on those types of documents or on that particular issue. So now that we've completed the legal review and quality checked everything, I'll talk you through the final checks we do before your documents are handed over to the other party. Before we provide the documents to the other side, there are a lot of quality checking procedures that happen. Just so that everyone understands what exactly gets disclosed, we will disclose anything that has been coded relevant and their family items. The types of quality checks we undertake are any document that is coded as relevant and any items in the family that haven't been coded, any document that is coded as relevant and has a privileged document in the family, any document that is coded as relevant and has a confidential document in the family, documents that are coded as relevant but contain a privileged term, and documents containing a privileged term that are not coded as privileged. And finally, once the disclosure is prepared, we quality check it against the document management protocol to ensure that we're supplying all of the fields in the correct format that we've agreed to. So now the fun bit, disclosure. The litigation database streamlines the process substantially. We simply produce an export MDB load file or a database file together with the documents in a format that complies with the protocol. So the amount of time required for this process really depends on the number of documents to be disclosed. You'll just need to factor in some time for us to produce the documents, so please chat to us to make sure that you have taken that time into consideration. Great, so now that disclosure is complete and it's time to take a break before you receive documents from the other side for review. So at ELMS, we believe it's really important to celebrate the end of the legal review process. So we would recommend a lunch or a party, and it would be all the more fun if you invite your eDiscovery provider or the friendly team here at ELMS to celebrate this achievement.
Agreed, Kira, agreed.
So once we've had the party, now let's talk about what we do when we receive the other side's disclosure when you are using a litigation database to manage the documents. Firstly, we check to see if the disclosure complies with the document management protocol. If the documents don't comply with the protocol, we will let you know and we'll give you a recommendation on how to rectify the issue. Sometimes it can be faster for us to fix the problem if we can, instead of you spending days in correspondence getting them to resupply the documents. We then check to make sure that they have not provided anything to us that has a privilege or privilege basis tag that hasn't been redacted. If they have, we will seek your instructions on the next steps. If everything does comply with the protocol, we simply import the documents and save them into a binder for you to review. We also work out what are the exact duplicate documents between their set and our set so that you don't have to review anything that you've already seen. The next step from here is to prepare briefs to counsel, master and issue-based chronologies, witness statements and expert reports, and then off we go to trial, and hopefully we can convince you to do an e-trial. So let's briefly discuss how we can help you with briefs to counsel, chronologies, witness statements and expert reports. Once these documents are finalised, we can create a fully text searchable hyperlink solution for you so that the document sets are easy to navigate around and you can provide them to the various external organisations for review. Our tip on this would be to make sure that your document IDs are put into these sets of documents so that when you provide them to different groups of people, we can make them fully text searchable either within the document or across the entire set. Start as you mean to go on. by starting in an organised manner and spending that extra few minutes to insert the document IDs into these kinds of documents will make everyone's lives so much easier when we get to the trial prep stage. So hyperlinking is a really good quality checking process, as it will also help you to identify whether you have any incorrect document IDs in your document or not. So in our next episode, we'll actually show you some examples of these so that you can see the benefits firsthand. Now I'll hand back over to Kate to talk to you about eTrials.
Thank you, Kira. So at Elms, we love a good e-trial. We don't like doing hard copy trials anymore, so we would certainly recommend that you go down the e-trial path. So firstly, what do you need to run an electronic trial? It's pretty simple, actually. Firstly, you just need an electronic court book, which will include all of the documents that you have in your agreed trial bundle if you lawyers can actually agree one. And then depending on the length and complexity of your trial, you might also want some real-time transcript and software to support you during the trial. Now, so for those of you who have not seen real-time transcript, when you are in court, the stenographer types exactly what has been said and the text appears on your screen, either in court or back in your office, which you can then mark up, annotate, comment on, copy and paste into an email. There's lots of different functionality within these particular tools. And the annotations that you make can only be seen by yourself and your team. So the other side don't get access to see any of your annotations. So each of those court books are kept separate so that only you can see what you've written. So there's a common misconception that setting up an e-trial is a really big deal. I can tell you it's certainly not. We have set up many in our time. If you've already got your documents in litigation database, we simply just produce either a spreadsheet or an export MDB database file to get the documents from the litigation database into the e-trial platform. And if you don't have a litigation database, then we will probably assume that you at least have your documents electronically. So which again, that just means you need to provide a list of those documents and they can get uploaded to the e-trial platform. So there's lots of options for an e-trial depending on what court you're in. If you are lucky enough to be in the Queensland Supreme Court, they've developed a really simple free electronic court book using a product called SharePoint. Now, it doesn't have all of the bells and whistles of the other platforms, but if you've just got a trial for 1 or 2 weeks, it's a really good option to reduce the cost of the trial overall. And there are many simple options that can also be used. We just need to work with you to find out what is the most appropriate solution for your actual trial. And if you have a longer trial, then you can work with an e-trial provider to implement the right technology for your needs. And if you're working with Elms, we will certainly organise that for you. And don't forget your arbitrations. You can also utilise these services in arbitration. And again, if you're working with us, we will organise it for you, but I'm sure your eDiscovery provider will organise these types of services for you should you require them for an e-trial. So it's an increasingly common view that conducting an e-trial can save up to 1/3 of trial time. So when you consider all of the costs that are in the room with all of the different barristers and solicitors, this can be an enormous amount of money. E-trials reduce document handling in court by between 25 to 30%, according to Justice Croft, who is the judge on the bushfires case. An e-trial can provide a forensic advantage to a barrister if they are correctly trained and understand how to use the system well. And I would certainly recommend pulling your barristers in and training them really effectively so that you can make sure that they can use this technology to their benefit when they're in court. E-trials can also reduce time back in the office after court, as you can mark up the real-time transcript and annotate it in live court while the trial is underway, as opposed to having to do that back in the office once you finished your day in court. You can also have your barrister reviewing the real-time transcript back in the office and then preparing closing submissions throughout the trial, and then get your senior barristers to review and settle it at a later stage. So this can really save many, many hours in both barrister and solicitor time and will reduce your legal spend during the trial. It can also improve the quality of cross-examination and re-examination of witnesses by being able to check exactly what was said right on the spot. So we know today's session that has been jam-packed with lots of information. So if you can just take away 4 things from this session, can you please let them be these? So take the time to brief your team really effectively so that you can get the best out of them as soon as possible. Second, use the tools in the technology to conduct your legal review, as it's going to save you time and give you confidence that your legal review was accurate and thorough. Talk to your eDiscovery provider about ways to speed up your legal review, because they will have lots and lots of ideas to help you along the way. And make sure you always select an eTrial over a hard copy one, as it's going to reduce the amount of time you're required to be in court, and a whole lot easier it is to manage your documents while you are in court. So there are our 4 things that we absolutely want you to remember. And thank you all for coming to our session today. If anyone has any questions, please just pop them in the chat box and we will answer them. But Kira, I already have one for you.
Yes.
Somebody wants to know, in a continuous active learning review process, what is the size of the documents, the sample size of the document set that you need to review for the computer to start to learn?
So we actually use the Australian Bureau of Statistics to determine the sample size, but it's actually not as big as you would think. So for example, we had a matter recently that was around 3 million documents, and the sample size was only around 350 documents. So this, it is economies of scale. So the sample size is definitely manageable.
And Kira, can I just pose a question to you? How prevalent do you think using continuous active learning is now? Like, could you just talk about how many requests we get to use that?
So like we mentioned in the presentation, we actually use it on pretty much most of, if not all of our matters. And it's definitely becoming a lot more popular. So any clients that have used it in the past pretty much always request to use it again, because you do get the benefit of speeding up that review time, and it kind of gives you an indication of how many projected positives or how many documents you will need to code as relevant before you can be satisfied that your review is complete.
Yeah, it is amazing tech. I remember when it first came in, what it would have been probably, I would think 8 or 9 years ago, everyone was really frightened to use it, but now it's pretty common practice now. So we would recommend to anybody that if you're talking to the eDiscovery provider, just ask them, is this something you can use on your project? Because you will see a pretty quick response to your coding decisions. It's pretty fantastic when you see it categorizing relevance first. We love it, don't we, Kira?
Yeah, we do. And we've actually seen it quite a bit now in a lot of document management protocols, actually mentions the option to use CAL or the likes. So it's definitely becoming a lot more used.
So there are no further questions that have come through at this stage. Terry, do you have any questions for us along the way?
I just had a quick one on this as I was listening to it, and it just seems increasingly the case that it's going to be very, very hard to effectively to work in this part of litigation, the discovery part of litigation, without really using these sort of tools or having them at your disposal. Is that a fair comment?
Yeah, I think that's right. I think you just need to be across what are the options that are available to you, because, even if you just collect one person's email inbox, it can still be thousands and thousands of emails. And if you've got a really short time frame, you have to do something to get you there a bit quicker. So if you just chat to your eDiscovery or give us a ring, we can just guide you through what are your options, what is the best way for you to proceed in order to get the best outcome for your client. So I think you're right. Given the volume of documents that we're dealing with these days, you really have to put this tech into play so that so you can help, and it does reduce the review cost and certainly time. So yeah, we would recommend just to chat to your eDiscovery provider and make sure that you're across all of the options. And sometimes eDiscovery providers can talk a bit techie. So if you don't understand, just tell them, can you please explain that in a different way so that I can really understand in my head what this technology is doing? So I'm sure if you ask them, they will be able to explain it to you quite succinctly.
Absolutely. And volume is definitely the name for today, isn't it? Just in terms of the amount of stuff that we're looking at now versus even a few years ago. It's certainly not decreasing. So
no, that's right.
These sort of tools and obviously your expertise around this and folks that work in your sort of line of work, increasingly important. Thank you both very much again for another fabulous episode in this series. Really, really clear, really, really helpful, really candid and practical too, which I think has been the hallmark of this entire series so far. So thank you again. Really looking forward to episode that'll get into the technology. So that's going to be.
We're going to blow your minds with that one, Terry.
Yeah, I know.
We're going to show you lots of tech.
Lots of tech. I know. I'm looking forward to all of them, but I'm really looking forward to just that, because the developments in that to me are just incredible, and how quickly those developments are taking place is also pretty amazing. So folks, do tune in again to episode 4 on the 18th of May to learn all about those tech tools. Thank you again, Kate and Kira. Really appreciate it. Thank you, everyone, for attending. Kate has mentioned, and the contact slide is here for you to reach out to them. You can find them in a whole bunch of places. So there's lots of opportunity to be able to do that and do that, because I know the Elms team is very happy, as they've suggested, to just help you out and point you in the right places, as well as obviously, I'm sure, very happy to do the work for you as well. So yeah, do reach out to them if you can. And of course, in terms of these episodes and the Centre for Legal Innovation more generally, please also feel free to connect with us and follow us on LinkedIn, Facebook, and Twitter as well. So with all of that said, and again, huge thanks to everyone who attended, and to you, Kate and Kira. It's a bye for now, right?
Thanks all. See you on the 18th.
Thank you.